I mean, what do we usually do in this situation?
Honestly, I've never had this happen, but
Other folks.
I would think that we can proceed. Can the jail not bring him down
Yep. He needs
to
to
do a
be
pro
brought
se?
in front of the
He
judge
needs to be
and,
brought, yeah.
be appraised of his charges so the Riverside issue can be handled. He's been reset since Monday.
Yeah, I don't have a strong on that. I need to find, does my office have a strong opinion on that?
Even if the jail can just, sometimes when they've used the jail court iPhone to hold it up to the cell, just so the person can at least be present for the hearing.
Yeah, he knows what he's charged with, and he actually, I believe he knows what he's charged with because he actually made it into the jail courtroom #1 before they took him back. But they just, there's only so much the deputies can put up with.
Yeah.
Like, can't have somebody that's that disruptive to other people.
Well, it sounds like you need to file a waiver on his behalf.
It wouldn't be a waiver, it'd just be a referral.
It wouldn't handle the Riverside issue.
Yeah, I mean, I don't have an authorization, so I'll just do it as a referral. Whatever language it needs to do, I'll just see if Dwayne's got a form. I know we
Ask
have
him what he thinks as well.
Yeah.
Okay.
We had an interesting morning at jail today.
The judge should be on momentarily, and I'm glad we're having this discussion so that perhaps maybe when she comes on, we'll be ready to proceed.
Oh, what's y'all's bond recommendation on Reed? The guy that thought he would have private lawyer, but the lawyer's tied up in trial. He hasn't paid him yet, so I'll just go ahead.
And this is the guy that refused to come to court yesterday.
Number 10.
Mm-hmm.
Yeah, he had that thing where line 1 was parole hold, line 2 through 6 were 4,000 bond each, and then the last line was our little bitty case.
I'm asking for a $4,000 good bond.
Gotcha. Given what's on the other line, probably get it. Let's see what else is there.
Mr. McClain, our friend Mr. Wolf, he's not on the calendar.
I just filed that accusation down. It's an add-on, so hopefully we'll get a document. But
there was an IT issue with one case that I just filed down, Taylor Bailey.
So are you saying we have 2 additional cases to hear?
Sounds like it, yeah.
Yes.
Let me run across the hall and get something on Wolf. Okay.
Mr. Bailey, he's not on our pull sheet. He wasn't on our pull.
I think it's a female. Her name's Taylor Bailey.
She wasn't on our pull sheet. And she wasn't interviewed either.
She was on our pull sheet. But when you pull up her stuff on the jailing screen, this case isn't on it. So that may be why she's not on your list.
The first name is Taylor?
Yes.
Mr. McClain, are you the only PD today?
Oh no, Keith's remote. He'll be on Zoom.
Okay.
Oh, and on Oscar.
Okay, I see you, Mr. Cook.
Okay.
Good afternoon. Good afternoon.
Good afternoon.
And while I'm speaking, I'll just let everybody know that the reset date for the SAP calendar is going to be September the 5th.
Thank you.
Mhm.
Mr. Osborne is a transfer to felony court.
Who's that?
Mr. Osborne, Oscar Osborne. We'll see.
He's going to felony court.
Yes, he's got 2 prior theft by taking convictions, and they have accepted that transfer, just waiting for a signed order. It's already charged, but yes.
Isn't interference with government property a felony?
I NOD'd that count.
Oh, you did?
There's no probable cause.
Yeah, because I saw it was kind of in the alternative, the way there were 2 affidavits.
excuse me, for Ms. Bailey, what charges?
It's a theft by shoplifting and criminal trespass.
Okay.
We checked on interpreter cases. We
I
interviewed.
think she actually paid her bond, Ms. DeCiano.
She's got a hold out of
And she has a
Henry,
hold,
so
she has a hold, but
She posted on second chance.
but she posted bond on those charges already. So we
Okay.
don't- Thank you.
thank you.
Everybody been interviewed?
Yep,
Do we have any conflict cases? We got a conflict attorney?
I didn't see any.
I saw none.
Okay. That's all the housekeeping I have.
Your Honor,
Ready?
there is an issue with the guy that keeps getting reset. I don't know if you want to address that
Wonderful.
now or when we get to him.
Who, he won't come out, he won't talk?
Yeah.
He actually came to the courtroom, but he simply says, that he refuses to talk. So he says that several times. And although I understand that some people, will do that because they want to stay in jail, and that may be exactly what he's about, nonetheless, the persistence after several days indicates to me that a evaluation would be worth it.
Yes.
Your Honor, does that address the Riverside issue? However, he was on our docket on Monday and has refused to come to court for the past 4 days now. He needs to be appraised of his charges.
Well, if he'll just stand in there and listen, he doesn't have to say anything. He came to the door.
No, today he actually was in the courtroom before court.
Okay.
But
Why didn't they keep him? Because he wouldn't stay. Go ahead, Mr. McLean. He came into the courtroom before. Then he said, I don't want to be here, and they took him back.
Yeah, well, yes, Your Honor. They felt that his presence with the attitude and everything was disruptive, I think, and I think that was the reason they took him back, was not to disrupt the court.
Can't they take him to the infirmary or to medical and let him participate that way?
Let's see.
We didn't take
Yeah.
him back because, we didn't take him back because of his attitude. We took him back because he refused to cooperate.
Yeah, well, it's sort of same. I got
That's
you.
not the same.
It's not the same. We're
Yeah, could
asserting the issue of his rights, and he's gonna end up with a bond and not be heard, and we need to address this. If he think there's something wrong with him, he needs to be in medical and he needs to be appraised of his charges, and you need to submit something for an order or for a evaluation.
Judge Mincy, I'm gonna take the
Yes.
cell over to the cell. And
Yes,
Thank
I'll
you.
put the camera on them. You guys do what you have to do.
great. Thank you.
Just give me a few minutes.
Okay.
All right.
And with that, Your Honor, I think we're ready.
Yes, we are.
Hello, pretrial. How are you today?
I'm here.
Very good. I can't see you. Uh-oh, he got quiet.
Give me a moment.
Ladies and I'll give you a moment before I
Yes.
start.
No,
Okay.
please start
Oh.
your speech.
Oh, okay. I'm sorry. All right. Good afternoon, ladies and gentlemen. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will be the defendant's initial appearance before a state court judge. So we are going to and are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. We're going to be providing a SAP reset date, which is September the 5th. I want to also begin by advising everyone that this whole entire proceeding is being live streamed as well as recorded, and that is live streamed on YouTube. I want to remind the defendants that you have certain constitutional rights you first have a right to representation and counsel at this juncture in your case. You should know who your attorneys are by now. And also you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences of your case can and will be held against you. So listen to your attorneys. All right, who do we have first, Deputy?
We can go with ACDC first.
Okay, ACDC.
Courtroom 2. This is gonna, good afternoon, Judge. This is gonna be number 11, Ms. Thomas.
Okay,
That'll be me, Your Honor.
all right. This is 24 CR 005893J. Jaslyn Thomas, charged with 1 count of battery.
7 total, 2022 FTA, 2021 simple battery against police, law enforcement conviction, 2021 disorderly conduct conviction, and 09 trespass conviction.
And that's
Okay.
my case, Your Honor. This is an incident that occurred at MARTA on the platform on the 21st of August. The defendant shoved another passenger, someone unknown to her, named Mrs. Holler, Holler, first name Lavinia, Lovenia, down onto the ground, causing her to have a cut on the back of her head from striking the platform. The defendant, it's noted in the police report, left the location to go drop her child off at daycare. So this was done in front of her child. And then she returned to the scene to turn herself in. Of note, her criminal history you just heard about is the failure to appear, but every single charge is related to either damaging someone's property or behaving disorderly or battering people. So in this situation, Your Honor, we're asking for a $2,000 surety bond, absolutely no contact with the victim, Ms. Holler, and stay away from all MARTA locations, no drugs, alcohol, or weapons while on bond.
Well, is it PD McLean?
Yes, Your Honor. She does work in the healthcare industry. She did return, which was, we don't see that very often in the police department. She did return to turn herself in after taking the child to the daycare. We would ask the court to consider a signature bond instead.
All right, I'm going to order a $2,000 surety bond. I'm going to order that she stay away from MARTA and not ride MARTA and not get on MARTA while she's on bond. I'm going to order no drugs, no alcohol, no weapons, no guns while on bond, and no unprescribed medication. And that's it. I think she has a question, Mr. McLean. I don't know if you want her to ask it or not.
I can call ACDC and answer the question later.
Well, actually, I wanted to say something to the judge if possible.
Well, as I explained, today is for the purpose of setting the bond. We're not going to be able to try the case and have.
I understand, but I want to put in my input because what's not being stated is I pushed the lady because she was displaying behavior around my child. And right now, I'm just trying to get to my child because my child is in a dangerous situation.
Yeah, you need to be careful what you're stating.
I'm trying to say my daughter right now, I had somebody to pick her up from daycare, and I don't feel like she is okay. That's what I'm saying. The whole situation, even yesterday, I felt like I was protecting my child. All I'm trying to do right now is get back out and get I sent my baby to my brother, and I thought she was gonna be okay. I found out he's back on drugs. And my sister is dangerous to be around children, and he's trying to send my daughter to him. She's 2 years old. I just need to be out to get to my child. I don't be doing nothing to nobody. I'm not gonna miss court. They took my bond money yesterday already. Because
Who
they didn't
took
plan
your
on
bond money?
my brother, and he bought drugs with it, and he has my daughter right now.
Yeah, well, the problem is your history's not good, and you've got other batteries, and seems like, that's not the way to
I don't
resolve
have any other
conflict.
batteries. That's why I look confused when he said somebody of battery conviction or something like that.
Yes, in 2022, was it not, Miss Allen?
She has a 2021 obstruction and simple battery that she was allowed to plead guilty to disorderly for. She's got a 2016 obstruction and pimping that she was acquitted for out of DeKalb. She's got criminal damage to property conviction. She's got a reckless obstruction and simple battery on a law enforcement officer she was convicted for in Clayton County, and that's a 2021 case. And she's got a failure to appear from 2022.
So are those not you?
The 2022 one that I played disorderly conduct. In 2019, I had a suicide attempt. They took me to jail. They got caught taking pictures of me naked. Now, I attempted to file a lawsuit. They took me back to Clayton County. I sat there for 8 months, gave birth to my child, and that's the only reason I finally took a disorderly conduct plea, is to get to the same child. Because the same family who I'm worried about her being with now tried to have somebody adopt her that wasn't even related to me. I had to go to court, and the judge told me, "You never lost custody. You could just want to see your child. I don't even know this woman. I don't know how she got my baby."
It sounds like you need to talk to your attorney and get some support.
Yeah, I'm just trying to say, I really, I understand your stance. I understand that I don't have any charge over my bond. I'm just trying to express to you, Judge, I'm going to do whatever you need me to do. If it means I'm part of a mental health program, I can just stay in my house. I don't even have to go to work no more if it means me staying out of trouble, okay? I'm not a troublemaker. I don't do nothing if I don't feel like I'm defending myself. I really am just trying to express to you, I really need to get my 2-year-old because I really feel like she's unsafe right now. And I don't have anybody to call. And that's all I'm trying to express to you. I'm not gonna miss it. The only way I even had the failure to appear is because Clayton County didn't bring me to that court date. I am not gonna miss the court date. I'm not gonna not show up. I'm not gonna nothing. I just, like I said, the incident yesterday, I felt like I was protecting my daughter, and right now I'm just trying to get back out and do the same thing. They already not gonna bum me out because they already spent that money. I'm just trying to
Right.
get to
And
that baby
you
because I feel like
understand
she's unsafe.
and you understand when you're in situations, even if you're defending your daughter, you must call the police or get some help before you're trying to do self-help or do it yourself, because
We were
then
on
it
the
makes you
train
look like,
tracks, and I
I
thought my baby was
understand,
gonna
but
fall
it
out of her
makes,
stroller, and so I just did something immediate, okay? And I do apologize, and I sincerely understand where you're coming from. I do.
but you gotta find a better way, because it appears that you're the one with the problem. And if you push some lady down and she's got a cut on her head, I mean, I don't understand how protecting your daughter, and they're accusing you of pushing someone.
I pushed her too because she was by my stroller and she almost knocked my baby out the stroller twice. And I kept saying, "Do you see my baby right here? Do you see?" And she kept doing it. So I just pushed. I wasn't aware. The reason when I came back to the station, once I noticed she was bleeding, that's why I went and talked to the officer. I didn't even know the lady was,
And
because
then
as
you
soon as
came
the
back.
elevator closed, I went on to take my baby to daycare. I just wanted the lady away from my baby displaying the behavior she was displaying and saying the stuff she was saying. Like she was making threats because I was like, "Hey, you're pushing at my baby's stroller. My baby might fall out." You know what I'm saying? And I'm not even asking you to dismiss it. I just really need to get to her right now. I understand
How
this
old
is not
are
my
you?
trial. How old am
How
I?
old are you?
I'm 32.
And you work?
Yes. I took a recent I took a short-term sabbatical because my car is stolen. So yeah, I took a short-term sabbatical, and we suffered some trauma in my home as well, which I'm just gonna be honest, I've probably been more protective than I should be because of the recent situation me and my 2-year-old just went through. So I have
No, you
probably been more
should
protective, and
protect your child.
I've probably been more on edge about my baby than usual because there's a police report in the system. Somebody came in our household, held knives, that's everything. But
Okay, well,
I
no,
have probably been more protective.
you should do all you can to protect your child, but she can't
And
protect
I'm
herself.
saying if it means I
Hey,
gotta just
hold on a
stay in my
second.
house, I'll just
Hold
stay in
on
my
a
house.
second. Okay, hold on a second. We're not gonna put you in the house arrest. State, are you, and I shouldn't ask this question, but are you opposed to a signature bond through pretrial?
We wouldn't be opposed to house arrest, Your Honor.
Hmm. Well, I've never done it before, but I could. Haven't had an opportunity to. you know, or as we call it, a curfew, maybe. So let's do this. I'm going to make this bond higher in case you default on it. This is going to be a $4,000 signature bond through pretrial. Okay. I'm going to put you at a level 1,
Can we look at level 3?
level 3. Okay.
Yeah.
Put you at level 3 through pretrial. It means you're going to have to report 3 times a month, correct? Pretrial?
Once a week.
I mean, once a week. I'm sorry. And I'm going to have you to take a 2-day anger awareness course. Make sure you can handle things, okay?
Yes, ma'am. The reporting, will it be in person or like via phone or something like that? Cause I don't have my car and my only transportation would be MARTA. That's the only reason.
So if it's once a week pre-trial, can she call in?
It's your order.
Okay, we'll let you call in
Thank
since
you.
you don't have transportation at the moment. And I'm still going to ban you from using MARTA. You can't use the train or the bus, so you're gonna have to get Ubers and other types of transportation. Because we want to make sure that the MARTA citizens are safe. So you can't use MARTA right now. And no drugs, unprescribed medication, alcohol, no weapons, no guns while on bond. Okay, so I'm going to give you a little grace today to let you out. Now, what does the house arrest of the curfew look like, ASG Allen?
Well, if she can't ride MARTA and she's taking a sabbatical and she doesn't have a car, she needs to be at the house unless she's meeting with her an attorney or doing some medical treatment or in school.
Okay, so that's what it's going to look like. I'm not going to put you on an ankle monitor or anything like that, but we're going to say that you are on house arrest, which means you must be in the house. Unless you're going to see your attorney, attending court, getting medical assistance, or what was the third thing? Or going to school. Do we say school or work or just school?
School or work is fine.
Okay.
We would request a
All right.
social worker visit.
Yes.
Sounds like there's some support that's needed. I am looking at a
Correct.
dismissal following pretrial intervention in 2023. This case, she did pretrial intervention. It was from a 2019 incident. She engaged in a fight on a northbound MARTA train. Car 306, arriving at the Lindbergh station, pulling the hair of another person on the train. So we would request some kind of evaluation. Who are you defending then, lady?
It was dismissed due to the fact that the other girl was a minor. She admitted I never touched her, and
It was
when they
dismissed
threw it.
because you completed
I'm
pretrial intervention.
answering your question, ma'am. From my
We appreciate it,
understanding,
Your Honor. Thank you.
You asked me a question.
Okay.
It was
Hold on a
found
second.
that they, when they took it out of magistrate court, they accidentally, instead of dropping mine, they dropped hers, and they got something mixed up. So they told me that if I just did volunteer work, they will make it go away because they don't understand how the accident occurred. She admitted I never touched her. She admitted she pulled my hair. She didn't have hair. She had a low haircut.
Okay.
But I never touched her, and she admitted to that. She admitted
Okay,
I
I
never
have to
touched her.
move on. Let me change this, and I want you to take a 1 week anger awareness just to make sure there's nothing there. We're gonna order a BHET, just so that they can maybe give you some resources to help with their daughter. But unless you're going to the attorney's office, getting medical assistance for you or your daughter, going to school or work, if you have a legitimate job to go to work, then you should be in the house, basically 24/7. And if you're caught out and they read this bond, they're going to see if you're going to, you know, I don't know, CVS to pick up a prescription, maybe that. And you know, I'll be honest, I'll just add, you know, the store. Because I know you may have to go out to get food or groceries. Okay. But other than that, you should be in the house. And I think that's good so that you don't get in any more trouble, any more disputes with anybody, any more arguments, any more whatever. Just maybe stay away from everybody for a minute too. You can get through the case, okay?
Yes, ma'am.
And remember now, if you don't show back up or if you FTA, it's gonna be a $4,000 bond starting out because that's what I'm making it higher. so that you will not have any more incidents, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Next, we can go with position number 1, Mr. Boone.
Twenty-four CR 0058888Y, Jeffrey Boone, charged with 2 counts of simple battery, family violence, pretrial.
You got 4 total. I didn't see any violence in this history.
Okay,
That's what I have too, Your Honor. I'm showing his last arrest was in 2011 for identity theft.
okay.
This is a case that happened yesterday, August 21st. Incident location is 6355 Oakley Road, apartment 609 in Union City. Officers responded to a domestic dispute call. There are 2 victims in this case, Your Honor, his wife, Pamela Boone, and her child, which my understanding is not the defendant's child, it's his stepchild. Initials, DG. The victim told the officers that the defendant slapped her across the face. And then the defendant also slapped the 14-year-old son across the face as well. The officer also reviewed video camera footage that showed the slap of the child. Your Honor, we have been in touch with Miss Boone today. She states that she and the defendant have been married since 2017. They have a daughter together. The victim is her 14-year-old son. They all reside at the incident location. She states that she's called the police on the defendant before, but this is the first time that he's ever been arrested. She states that he's also hit their daughter in the past. She states she and the children are afraid of him, and the defendant's been trying to throw her and the kids out of the apartment. She's in the process of moving, but needs time to save money. And she would like at this point no contact with her or her children and to stay away from the incident location. The state's requesting a signature bond through pretrial, Your Honor, no further contact with either victim, stay away from that incident location, a week of anger awareness, no weapons, drugs, or alcohol while out on bond. And if the court can sound for Miss Boone.
No.
All right, Ms. Benton.
It's Miss Boone.
Oh,
Pamela.
I'm sorry.
Boone.
Pamela Boone, same name. All right, go ahead. No, Miss Boone.
Your Honor, that's my case. We have no objection to this signature bond. Would object to the anger awareness, and we would like one-time Leo law enforcement visit to collect his belongings.
All right. I will order a $3,000 signature bond through pretrial. And that's $1,500 on each. And one-time law enforcement escort to get his belongings. Stay away from the incident location. And no drugs, alcohol, unprescribed medications, weapons, or guns while on bond. And no further contact. This is his wife. I guess if he's staying away, no further contact for now. Make sure there's been the ample cooling down period. Anything else, counsel?
What level would that be, Your Honor?
Pretrial is at a level 1 or 2?
1.
Okay, level 1.
Thank you.
Mm-hmm.
Nothing further from the state, Your Honor.
Oh, I think, did you all ask for anger awareness?
Oh, I did.
course? I thought so. Let's do a 2-day anger awareness for pretrial. And I think that's it.
He's got a question.
What's the question? I don't know. Your attorney may not want you to ask it.
Mr. Boone, you have a signature bond. I would not say anything further at this point. You know,
But I have no choice but to say something. I'm on physical therapy. I just got out of rehab. That is my apartment. I have nowhere else to stay. She has sister, mother, father, and brothers that she can go stay with. This have been, I apologize. It's no more, but it's only a certain amount. You saying go there and get my stuff with the policeman. Sir? Madam?
Yes, that was there.
That's what we're saying.
Okay, so when I go there, I can go there with the truck and get everything belong to me, right?
Yes,
And I can turn the apartment back over to the people I'm renting from, right?
that's what you want to do.
Okay.
I don't have an order against doing that. Just don't
know,
go alone.
I can't
And I'll be honest, huh?
Your Honor, the officer's not going to let him clear out the apartment, to be clear. These folks are married. This is marital property. It's my understanding when these things
You can
happen,
just go get your clothes and they
if
give
there's a
you about
dispute over
30,
items,
45
those things stay.
Right.
This
They'll
woman,
probably give you about 30, 45 minutes.
this woman abandoned me in the other apartment.
We're not here. This is not family court. So we're not talking about that. We're talking about this incident of these 2 counts of simple battery.
All right.
Okay. So then you got to work out all the other stuff or file for a divorce, do whatever you need to do. But you're only going to get a very short window to go back and get some clothes and personal items.
About an hour to go in.
I don't know what the police are going to allow. Depends on their calls and their availability. Usually is less than an hour, very short. But they will tell you. And just as sure as I say that, they might tell you got 10 minutes. Get a plastic bag or 1 suitcase and go. And then the rest can be sorted out later.
Okay.
All right.
Thank you.
Thank you. Mm-hmm. Next.
Next, we'll go with position number 11, Mr. Varner.
Who did you say number 11 is?
He's
No,
number
that's
12.
I'm sorry, position number 12.
That's okay. 24 CR 005810F, Brandon Varner, charged with certain acts on a bus rail station prohibited and willful obstruction, pretrial.
This is 9th arrest. Last was August 4th. Trespass, obstruction, on probation for robbery, ag battery, theft by taking. What else? Also on probation for ag assault. Another probation, 2 counts of obstruction, possession of cocaine. Open case out of DeKalb County for trespass, obstruction, and certain acts. 2019 probation, 2018 probation.
Your Honor, that's my case. This is the defendant who has been in custody and on the SEA calendar since Monday. The report from the 17th of August at the Buckhead MARTA station states that between 3:30 and 5:40, he was walking on the tracks from the Buckhead MARTA station to Medical Center up in Dunwoody and interrupted service for MARTA for that 2+ hours. So the incident location is 3860 Peachtree Road Northeast, where he got on the tracks, and all the way to 5711 Peachtree Dunwoody Road. He refused multiple verbal commands, ran from officers, refused to stop when told, pulled his arms away when being detained and cuffed, and refused to get on the ground. My understanding is that he's refusing to speak to anyone, so we would join in any recommendation for an evaluation or argument for bond, Your Honor, based on the criminal history and the use of resources to deal with this kind of situation and disruption of train service for over 2 hours is a $2,000 surety. Stay away from all MARTA locations and no drugs, alcohol, or weapons while on bond. Thank you.
I'm going to say, do we need an MHET?
I believe that makes sense, but I think the defense.
We agree. The HET or MHET, whichever the court thinks is appropriate.
I'm going to do MHET. And are you agreeing to the 2,000 surety bond?
Your Honor, we're going to leave that in the discretion of the court.
Okay. I'm going to order that 2,000 surety bond, 1,000 on each charge. Stay away from, I guess, all MARTA at this point. I'm sure they banned him anyway after that whole fiasco. No drugs, alcohol, unprescribed medication, weapons or guns while on bond. And please do an order for MHET.
And let me reassure Mr. Varner that if we can come to the jail and talk to him, if I can find out any information, we will follow up with a further bond request on his behalf. I'll come to the jail and see him.
What was that bond amount? I'm sorry.
2,000, 1,000 on each. 2,000 surety. All right.
Next, we'll go at position number 2, Mr. Brown.
24 CR 005889Y, Kenneth Brown, charge of 1 count of terroristic threats. Pre-trial.
Fifth arrest, 2020 battery DB. It was reduced to disorderly conduct conviction out of Gwinnett. 2013 assault FTA. That's it.
Okay. All right, state.
Your Honor, this incident happened on July 10th of this year. This is a dispute between an attorney and a former client. This dispute happened at the attorney's office, 2620 Buford Highway in Atlanta. The victim in this case is attorney Dwayne Kinney. I believe he's on the Zoom. He reported that the defendant is his former client. He came into the office. He started an argument over a previous case. During the course of this argument, the defendant threatened to harm him, said he would be waiting for him when he left work, and that the defendant would make sure that he would not make it to work the next day. We have been in touch with Mr. Kinney today. He states that this was a situation where the client was terminated. The law firm had filed a lien against the defendant for unpaid services. The defendant then got very upset and went into the office and started causing a fuss. The defendant was asked to leave numerous times, but he would not. The defendant was heard making threats. The victim stated that he would like to settle the lien with the defendant, but he would like for him to do so through the other employees over the phone about it and have a no contact with him directly or and stay away from his office building, the 2620 Buford Highway. Your Honor, based on this defendant's prior conviction and the state's position is that this defendant is dangerous, especially to other attorneys who are trying to get paid. This kind of behavior should not be acceptable in any form or manner. The state's requesting a $3,000 surety bond, absolutely no contact with Mr. Kinney, a stay away from his office at 2620 Buford Highway. Your Honor, I am asking for a surety bond, and the state would ask that the court also order him to take anger management through whatever private companies provide that service. No weapons, drugs, or alcohol out on bond. And if the court can sound for Mr. Kinney, he's on the line.
Mr. Kinney?
Yes, ma'am, Your Honor, I'm here.
Okay, do you wish to address the court today, yes or no?
Everything that's been presented by
No, listen to me. Do you wish to address the court today, yes or no, is the first question.
No, ma'am, Your Honor, I have nothing further to add.
Okay, if you did, I was gonna swear you in and then you could talk, but if not, you can just listen in and I will listen to his attorney and then give my ruling, okay?
Yes, ma'am.
Okay, all right. Go ahead, Mr. McLean.
That's my case, Your Honor.
Oh, I'm sorry, Mr. Cook.
No problem. My client has lived in the Atlanta area for 7 years. He works for FedEx. He would dispute the allegations as stated in the warrant. We would not object to a stay away or no further contact. We would be asking for a signature bond at whatever level the court deems appropriate.
All right, I'm going to, how old is Mr. Brown?
Brown is 34.
What's the connection between him and the victim?
None.
None?
I don't have no reason to go there.
All right, I'm gonna order a $3,000 surety bond. I'm gonna order a stay away from the incident location, no further contact with Mr. Kenny. And I order a 2-day anger awareness course, place of his choice. No drugs, unprescribed medication, alcohol, weapons or guns while on bond. That should be it.
Appreciate it.
Next, we have position number 3, Mr. Clark.
This is 24 CR 005891D. DeAndre Clark, charge of 1 count of battery, 2nd count of simple battery.
7 total. Resident of Birmingham, Alabama. 2022 FTA, 2018 probation. He's wanted out of Newton County for robbery. That's it.
Right?
Your Honor, this incident took place on August 21st, around 4 in the morning. Officers were dispatched to 3651 Lenox Road, Unit 1170, regarding a fight in progress. It's the state's understanding that this is the defendant's residence. The victim in this case is London Stevens. She told the police that she's friends with the defendant. She came over to his house around 2 a.m. to hang out. She declined the defendant's advances. There, he got upset after that, grabbed her around the arms and pushed her to the ground. The victim then got up and the defendant pushed her to the ground again. The victim had cuts and scratch marks on the upper sides of her arms, a cut on her lower lip, and small cuts on her hands. Your Honor, we have not been in touch with Ms. Stevens today, although I do believe she is on the Zoom. Your Honor, the state's requesting a $2,000 good bond on the battery and a $1,500 good bond on the simple battery. No further contact with Ms. Stevens. Anger management course. No weapons, drugs, or alcohol while out on bond. And if the court can sound for Ms. Stevens, thank you.
Ms. Stevens? Said you saw her on here, no?
I see a London's iPhone. Her first name is London, so I assume it's her, but
London
she
Stevens?
may not want to speak.
Okay, that's fine. We'll keep moving. PDs?
Yes, Your Honor, that's my case. My client was visiting the Atlanta area, and does not know the alleged victim very well. He denies the allegations as stated in the warrant. We would be looking for a signature bond. It's through pretrial services. We have no objection to stay away or no further contact.
Did pretrial say he's a resident of a different state?
Yes, Alabama.
Okay, Your Honor, we'd also argue that this defendant's a flight risk as well based on his lack of community ties. Thank you.
I'm going to order the 3,500 surety bond, 2,000 on the battery, 1,500 on the simple battery. And I'm going to order no further contact with the victim, London Stevens. And she does not reside at that address, correct? I think
That's
that's
the
his
state's
address.
understanding. I don't believe so.
But he's supposed to stay away from her, 200 yards away from her. Have no contact with her. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond. And I didn't hear you say whether he was working or not. I don't know if he has money to take an anger awareness course or not.
He is not working at this moment and has no income, Your Honor.
Okay. All right. I won't order that for now. Next.
Next, we'll go with position number 9, Mr. Osborne.
Yeah.
I thought you said transfer to felony.
Oh, let's transfer it to felony.
You don't have to sit down.
Okay.
I'll take that.
All right.
It has been transferred, Your Honor. But if you want to address bonds, you can.
Yes, I'll be back. I'm going to get my charge.
Ms. Holly, is Mr. Jordan near you?
He's here, but I do know that we still have to address his bond on this here theft by taking. Would you like for me to ask him to come on, please?
No. I guess not. We'll just go forward.
Your Honor, the defendant has 2 prior theft by takings. The incident here in front of you today involves taking a duffel bag, government issued bag with police items off of a police motorcycle parked in front of a police station. This was observed by witnesses and captured on camera. I don't know if the bag was actually recovered. This is a misdemeanor level theft as far as the value of the bag, but because of his criminal history, it is a felony and it has been accepted by the DA's office. We'd be asking for a $2,000 surety bond, Your Honor. No drugs, alcohol, or weapons while on bond. Thank you.
All right. It is. Did he cook?
No, Your Honor, this would be Mr. McLean's.
Oh, sorry, I'm on mute. Now I'm not. Your Honor, I did go ahead and ask him if he was aware or if he had any knowledge of whether everything was recovered or anything was recovered. And he told me that everything was recovered and nothing was lost. Now, given his situation, I can't vouch for how accurate he feels or how firm he is in believing that, but that's for what it's worth. Your Honor, he did not have anything really remarkable to say about it. He was hungry at the time. He realizes that this is not the way to go in the future. So we would ask the court to consider a signature bond. I believe it. The bag is one of those leather type bags that's on a motorcycle side. I think it was worth $330. But he says he believes it was recovered and nothing was taken.
I don't have any evidence of that. I'm going to order a $4,000 surety bond. I'm gonna order no drugs, alcohol, weapons, or guns while on bond. Stay away from the incident location and no further contact with the victim.
What was
That's
that
it.
amount? What was that amount?
4,000.
4,000. Okay, thank you.
So the other charge is dismissed, the interference.
Yes, I filed an NOD on that charge.
Thank you. Next, we'll go to position number 4, Mr. Evans.
This is 24 CR 0058878 Robert Evans, charged at 1 count of battery family violence pretrial.
10 total, 2022 FTA, 2020 false imprisonment conviction, 2017 FTA, 2013 probation. That's it.
Okay,
Your Honor,
stay.
this incident happened June 3rd of this year at 502 Prior Street. Police were called in reference to a dispute. The victim in this case is Janice Robertson. She advised that she returned home and her boyfriend and her child's father began holding her down and started punching her. And she told the officers that she wasn't sure why she was being punched, but that did note that the defendant had been drinking at the time. The officer noted the victim had redness and swelling to the left side of her face. We have been in touch with Ms. Robertson today. She states that she and the defendant have been together approximately 4 years. They have a 1-year-old child together at the incident location. She states they don't have a DV history. She's not afraid of the defendant, and she states they were both intoxicated when this happened. And she would like to continue contact and have the defendant return home. Your Honor, I do believe she's on the Zoom. There is the false imprisonment conviction from 2022. There was also a battery family violence component to that was null prossed. There's a concern for this victim's safety based on his recent history with that. And if she chooses to testify, we'd like to inquire if she was the same victim in that case. The state's requesting a $2,500 good bond, no contact and stay away, anger awareness course, no weapons, drugs, or alcohol while out on bond. And if the court can sound for Ms. Robertson.
Ms. Robertson. Ms. Robertson, are you there? If you want to speak, fine. If not, we'll move on.
Yes, I'm here.
Do you wish to address the court today? Yes or no?
Yes.
You do. You have to turn on your camera to be able to see you, and I'll swear you in first.
Hold on 1 second. I don't know how to do that. Would you be able to help me with that? I'm keep pressing. Okay.
Can't get it shortly. I'm gonna have to move on. All right, PD, the defense. You can
Your
mute
Honor.
yourself if you can't figure out how to work your camera. Go ahead.
Your Honor, my brief conversation with Ms. Robertson was the same. We'd be asking for no further violent contact, a signature bond to whatever level the court deems appropriate, no stay away, and no anger management. They do have a child together and have been, well, I'm not sure how long they've been living together, but she expressed to me no fear and would like him to come home.
And this occurred.
This occurred back in June, Your Honor, June 3rd.
Okay. I will order the $2,500 surety bond. With that surety bond, no further violent contact with the victim. Stay away from the incident location. And for the anger management course, 2 days. No drugs, unprescribed medication, alcohol, weapons or guns while on bond.
I believe that's their residence, so if,
For the two of them? Well, I didn't tell them to stay away. I said no further violent contact.
okay.
Your Honor, I have it as you saying for him to stay away. So are you saying no, he can go back?
Oh, I didn't know I said stay away, did I?
Yes, you
Because
did.
I said, okay, no stay away, no further violent contact.
Okay.
Next, we have position number 5, Mr. Harris.
This is 24 CR 0058885Y, Richard Harris. Charge of 1 count of battery, family violence, 2nd count possession of marijuana less than an ounce. Pre-trial.
27. 2021 trespass, possession of marijuana. 2016 probation, 2013 probation. Damn. 2012 failure to appear. 06 ag assault conviction. That's it.
All right.
Your Honor, this incident happened August 21st. Officers responded to the Crystal at 349 Cleveland Avenue. The caller stated that there was a man and described him who had punched a woman in a wheelchair in the head. The officer arrived on scene and immediately found the defendant as the person matching that description, detained him. The victim in this case is Linda Miller. She is the defendant's mother. She told police that her son has an MH diagnosis and is not being compliant with medication. And she stated that both of them are homeless. And she was asking her son to get her phone, and he just started punching her. The victim had a bruise to her left eye, and a search incident to arrest located marijuana. We have been in touch with Miss Miller today. She states that she's the defendant's mother. She did confirm that there is an MH diagnosis and that he should be on medication, but he is not at this time. She states that the events in the warrant, she confirmed them. She is not afraid of him. She would like to continue contact, and our office did reach out to her to see if we could provide services since she's homeless. Your Honor, the state, as far as contact is concerned, this woman is elderly. She's in a wheelchair. She's handicapped. We have a situation where she has a child who has an MH issue and possibly an issue with resources for to get required medications for stabilization. So the state has a reasonable concern for her safety at this point, given that this incident happened yesterday. And this is not the first violent offense in this defendant's criminal history. So the state would request a $2,500 good bond for the battery, no contact with Miss Miller at this time, a stay away from the Crystal, a BHET, anger awareness course, and no weapons, drugs, or alcohol while out on bond. And if the court can sound for Miss Miller.
All right. Miss Miller. Linda Miller. All right, PD.
And Your Honor, I'm sorry, before you begin, Mr. Cook, for the possession of marijuana, a $500 surety bond or a SOB jail. Thank you.
Okay.
Your Honor, they are, from our understanding, both homeless. I don't have any objection to the state's recommendation. We would ask for the SOB on the marijuana through the jail.
All right, I'll make it a split bond, 2,500 surety on the battery, 500 signature bond through the jail on the marijuana. And I guess BHET to help with some resources for living arrangements. And I wonder, can I order no further contact with the victim? And I guess I will, since it just happened and we need the cooling down period. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond. That's it.
Position number 6.
24 CR 005886 D is in dog. And that will be Darnell Harrison, charged with 2 counts of battery, family violence, and 1 count of cruelty to children in the third retrial.
15. 2018 theft by receiving. Possession of a Schedule 4. Possession of marijuana less than an ounce. Reckless conduct, obstruction out of cob. 2018 reckless conduct conviction. 2017 probation. 2016 battery, cruelty to children conviction. That's it.
Okay.
Your Honor,
PD?
this incident happened in March
Mistake.
of this year, March 12th. Officers responded to 151 Elysian Way regarding a physical dispute. The victim in this case is the defendant's wife, April Harrison. She told her husband that she needed some time apart from him, and he got upset and put her in a headlock and punched her in the chest. The victim was able to break free, and then he put her in a headlock again and drug her across the floor. The victim's son, who's 15, initials QJ, intervened at this point because he heard what was going on and came to get the defendant off his mother. And the defendant then began punching him. Miss Harrison had abrasions on her feet and her neck. The child had an abrasion on his collarbone and scratches on his arm. We have been in touch with the adult victim, Miss Harrison, today. She states that these folks have been together for 6 years, married for 4. They don't have any children together, but they have 3 children who reside with them at the incident location. She states they don't have a domestic violence history and that she and her son are not afraid of the defendant. She confirmed the events in the warrant, states that there's been no further incident since this one happened. She would like to continue contact and would like the defendant to return to the residence. Your Honor, of note in his criminal history, he does have 1 prior conviction for battery and cruelty in the third from 2016. However, there was also an incident from 2013 or 2014 where he was charged with battery, family violence, and 2 counts of simple battery and 1 count of battery, where he completed diversion for that. And then he was also arrested in 2016 for simple battery and cruelty in the third, and that case was null prossed. So we have a situation here where this is now this defendant's 4th arrest for battery in the last 10 years. The state has a concern for the victim's safety here, especially considering one of the victims is a minor. So at this point, the state's requesting a $5,000 surety bond, $2,000 on the batteries, $1,000 on the cruelty, no contact with these victims, stay away from the incident location. Your Honor, the state's also going to request that he enroll in FVIP, no weapons, drugs, or alcohol while out on bond. And I believe Miss Harrison is on the line, Your Honor. Thank you.
Ms. Harrison,
Yes, ma'am.
do you wish to address the court today? Yes or no first?
Yes.
Right, raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. Ask you a couple of questions. Are you in fear of Mr. Harrison?
No, ma'am.
Do you want to have any further contact with Mr. Harrison?
Yes, I do.
All right, nothing else? Anything cross-examination by the state or the PDs?
I'll ask a question, Your Honor. Miss Harrison, does your son, the 15-year-old, does he live with you?
Yes.
And does he ever spend time with his father where he's not living with you?
His biological father?
Yes.
No, his biological father is deceased.
Okay. And since the time of this incident, has there been any sort of would it support your family if your husband was ordered to take anger management or something of that nature?
Yes, I do believe that will be helpful.
Okay. And would it support your family if your husband was required to enroll in a program for domestic violence and how to prevent those things from happening?
Is that the type of program that would prevent him from being able to work?
No. It's just a program that's designed to help in this kinds of situations where you have anger in the home, in domestic situations, how to prevent that, and how to prevent these kinds of things from happening again. Would that sort of thing support your family at this time?
Yes, because that's not a regular occurrence. It could be useful, especially if that will, help him today.
Thank you, Ms. Harrison. That's all the questions I have.
Okay.
PDs?
Yes, Your Honor. We would be asking for no further violent contact. We would like him to be able to go home and have again no violent contact. We would object to a stay away. We would not object to any of the courses suggested by the state. We would be seeking a signature upon you.
Okay, I'm going to order the $5,000 surety, 2,000 on each of the batteries, 1,000 on the cruelty. And I'm a little confused which way we're going with this, but I thought the state requested a stay away and no further contact.
We did, Your Honor. At this point, this incident happened 6 months ago, and the reason I asked those questions was in case the court's going to order no further violent contact. There's some other things. I'm sorry, what'd you say, Ms. Bridgewater?
Think she wasn't talking to us.
Okay.
All right, so we're not doing the stay away.
Your Honor, the state will leave it in the court's discretion at this point. However, the state did request, based on his previous history, that there be no contact and that he be ordered to take family violence intervention at this point, or at the minimum, some kind of anger management. The victim is asking for no further violent contact at this point. And the state's concern with that is that this is now the 4th incident with this defendant and violence against intimate partners.
Okay. So no further contact with the victim, stay away from the incident location, and
Your Honor, may I speak?
no drugs, alcohol, weapons, or guns while on bond. Yes, Ms. Harrison?
Yes, I'm a breast cancer patient, and my husband is my caregiver. I recently completed chemo, but I'm still recovering, so I'm actually in need of my husband to be here. I did not want a stay away. I would prefer him to be here because I'm still in need of his help here.
Okay. You say you all do or don't have children?
We have 3 children in the home, just not together, but he's been a father to those children since their father is deceased. My son was actually with him when he was arrested. He was taking him to school.
Well, still, because of his history, 15 cycles. And I'll just go ahead and stick to the 5,000 surety. 2 on each of the batteries, 1 on the cruelty. No drugs, alcohol, weapons, or guns while on bond. And so, state, if we're saying no further contact with the victim. And I guess I would have to also do the stay away. Unless you all give me some more evidence or reason not to enter that.
Your Honor, again, that's what the state's requesting at this time. The state's also requesting that he be required to enroll in FFIB.
And I'm not going to require that right now.
The defense is asking for the no further violent contact, Your Honor.
Okay.
Per Ms. Harrison's request.
All right. That is all I'll order at this point.
So what's Your Honor ordering as far as contact goes?
No further violent contact.
Okay.
Thank you, Your Honor.
Mm-hmm.
Would Your Honor consider if the court's not inclined to do FFIB at this time, would the court consider anger management courses instead?
If he has the ability to pay for them.
And Your Honor, the victim did testify that she felt those services would be helpful for her family at this time.
Yes, see if they can find a one-day anger awareness course.
Thank you.
So, Your Honor, we're doing a no further violent contact. What about the stay away? Is it a stay away or no?
No, I
Okay.
believe. No.
Okay. So just
All
no
right.
further violent contact.
Correct.
Thank you.
I don't know what question your client could have.
Ma'am, I'm sorry. I just wanted to ask because like I am her caretaker, but I also have to work. And since like she's been doing this cancer and going through her treatment and stuff like that, she's not been able to work. So I'm like the provider, but I don't have any extra money for anything. I don't even have money to pay this bond. That's why I was asking for a signature bond so I can get back to her so I can help her.
Well, but we can't have any incidences.
I apologize for my actions. I'm not opposed to the anger management. Do y'all have like a free program of anger management that I can go to, or like something that y'all could refer me to? How many other anger management classes or whatever y'all feel like I need or whatever, I'll take them. I don't have the extra money to pay this bond. I have my money to take care of my family and to take care of her and her needs. Like she needs things after her chemo. Her medication isn't cheap.
Well,
So
I am concerned about what she's going through right now, but that's not the person to take your frustrations out on if that's in fact what happened. So that concerns me. The only thing that makes me feel a little, don't cut me off. The only thing that maybe makes me feel a little better is that it happened in March, and I'm assuming nothing has happened since March.
No, ma'am, we've been living together. That's my house. That's my home. Like, that's my wife. Like,
well, but people violate that trust.
I understand that.
Just because that is, don't make me think, oh, well, I didn't do anything. If that were so, you wouldn't be here.
You're absolutely right. I apologize for my actions, ma'am. I know I was wrong. And all the ones that's in the past, they haven't been like, I know what it says, but it's been like instances where people have attacked me and I'm protecting myself, but I'm the one who gets arrested. Can you understand that? Look how big I am, and the woman is small, and if I grab her to keep her from hitting me, I'm getting arrested for defending myself. But in this instance right here, ma'am, I can't say that I wasn't wrong. I was wrong. But I don't have no extra money to pay no bond for anything when I need my money to take care of my family and for her medication.
And with this one, the victim is not on the line, right?
She is, Your Honor. We've heard from her.
Oh, that's right, Miss Harrison. And Miss Harrison said that she wasn't afraid of him and needed him to help care for her. Is that correct?
Yes.
Yes, ma'am, that's correct.
All right, I will not do the stay away, no further violent contact. But, you taking pretrial?
I wasn't listening. What happened now?
Well, nothing. She's going through chemo and he's
Your
helping.
Honor, if I might interject, we're talking about Ayala factors in this situation. This case involves an assault on a juvenile that is not this gentleman's son. This did happen 6 months ago, but he has priors against other women. There is a concern for the safety, not of just his wife, but of the children in the home. We don't have any documentation at this point about the requirement for this gentleman to act as a caregiver. The Ayala factors, I think, are what are governing, and we would ask that the court just enter. There's already been an allowance for no violent contact. Now the defendant is asking for free anger management classes and a sign-on bond. He's not eligible for that based on pretrial recommendations, based on any recommendations at this point. And frankly, if this cancer situation were something that we should be appraised of, I'm surprised it didn't come out through defense counsel.
No, nobody asked me.
No, she's not talking about you, Ms. Harrison. Please refrain from speaking.
At a certain point, there needs to be advocacy on the part of an attorney, not the last-ditch effort of every single defendant begging for mercy or special treatment at the end after the court has made its decision.
Mm-hmm. All right. Well, I'll leave it at the 5,000 surety, 2,000 on each of the batteries, 1,000 on the cruelty. This is something about what occurred in the situation that bothers me a little bit, that there's more going on. And hopefully we won't be back at that situation in another few months. And I think that the defendant will have to learn how to manage his anger, during his situation. You know, it's not an easy situation, but you know, I want to stick to the ruling, and think we had no further violent contact. Did I have a stay away or no?
No.
No stay away. All right, I'll leave it like that with no stay away, no further violent contacts. If he makes bond, then he can go home and act right. So that's where I'm going to leave it. And put your hand down, Mr. Harrison, and your attorney will talk to you. All right, that's it.
Add on number one. Come on, man.
Judge, did you get that calendar?
Yes, I have it.
Okay.
Yeah, I was cooperating today. 24 CR 005895B, Michael Wolf, charged with 2 counts of battery, family violence, 1 count of simple battery, pretrial.
Who's knocking on the door? Who is this?
Mr. Wolf, add-on.
The add-on, I'm sorry.
Oh, 22, 2014, possession of drug-related objects. Probation violation, 2009, terrorist threat, simple assault, obstruction, conviction. 08, battery DV conviction. 07, simple assault conviction. What is that? 04, ag assault, possession of a firearm by convicted felon. Possession of a firearm during a commission conviction. That's it.
Your Honor, this is my case. This was a late add-on to our calendar today. So in conjunction with what pretrial just explained, there may be a prior battery family violence out of a different jurisdiction that would turn this case into a felony. Nevertheless, we've moved forward here. In front of you are 2 counts of battery family violence and 1 count of simple battery. This is an incident that occurred on the 4th of August, Your Honor, between 8:30 and 9:30 a.m. at 912 Mercury Drive. The victim in this case is the defendant's mother. She's 72 years old. She went into the police station after the fact and reported this incident. She was seen to have visible injuries, including a knot on her forehead and swelling where her son had punched her in the face. She had been thrown over a railing that was captured on video camera from the Ring doorbell camera. She had cuts and bruises and scrapes to her knees, both of them. When the defendant left taking her vehicle, she actually climbed into the bed of the truck, and he physically removed her from the bed of the truck, throwing her to the ground. That's the basis of the simple battery, Your Honor. We have not been able to get in touch with the victim, Mrs. Brown, Annie Brown, in this case yet today. We will continue that effort. But at this point, Your Honor, not only will we be requesting a felony transfer or upgrade based on criminal history, but we'd be asking for a $5,000 surety bond. Absolutely stay away from the location at 912 Mercury Drive, and no contact whatsoever with Miss Annie Brown. No drugs, alcohol, or weapons while on bond.
Miss Annie Brown on the line. All right, Petey Cook.
And this isn't my case, Your Honor. I have not interviewed him.
Oh, McLean.
You're muted.
Thank you. Given the allegations and given the overall history, we would ask the court, while considering a signature bond, if the court would not be leaning towards a consider bond in the neighborhood of approximately $1,500 to $2,500.
Going to order the $5,000 surety bond, $2,000 on each of the batteries, $1,000 on the simple battery. Stay away from the incident location. No further contact with Annie Brown. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond.
The breakdown on the owner again, sorry.
2,000 on each of the batteries, 1,000 on the simple battery.
Thank you.
Number 7.
Twenty-four CR 005890C, Jaquan Holmes, charged with 2 counts of interference with custody.
First.
And Your Honor, that's my case. This is a slight bit complicated, but because we've all got some experience in both the civil and the criminal arena, I feel sure that we can follow the path. The charges of interference with the custody are based on the fact that the defendant and the victim in this case, Mrs. Brianna Pope, share children and they are not married. Until July the 16th of 2024, they had a soft agreement about an exchange of the 2 minor children they share. I believe the children are 2 and 4 years old, Your Honor, Giovanni and Journey Holmes. Ms. Pope lives in Florida now, and she reported that on the 16th of July, their father came and picked them up as agreed, and he was supposed to return them on July the 30th. He did not do that, and instead he filed for an order for protection here in Fulton County. An ex parte order was issued. As you know, when you request an ex parte order, that's done in front of a judge without notice given to the respondent, and a hearing is set later to determine whether or not the order is going to be issued for a 12-month period. So after mom has had her children taken away from her, I believe there's back and forth between these 2 individuals through Fairburn Police Department. The father, Mr. Holmes, in front of you, also files for legitimation because he has no legal custody or visitation rights to these children. A final hearing was held on August the 19th, Your Honor. So Mrs. Pope in Florida had her children removed from her by their father July the 16th and did not receive those children back into her care until yesterday when he turned himself in on this interference case. In court, August the 19th, 2024, in front of a Fulton County judge on the TPO case, in the presence of the defendant's mother and other family members, the defendant was told unequivocally that he had no legal rights to these children and that they needed to be turned back over to their mother. An order was put in place commemorating and documenting that, and in a flagrant violation of the court's order, the defendant and his family refused to relinquish care back to Mrs. Pope. That resulted in interference with custody charges that were filed through Fairburn and are now in this court, Your Honor. The state, in recognition that there is no criminal history here, is going to be asking for an SOB through pretrial. We would ask for level 2. We're also asking for no contact with Ms. Pope or her children until further order of the Superior Court on the issue of legitimation, visitation, and custody. And we would request that the no contact order be very clear, and it include the family members of this gentleman, Mr. Holmes, who also were in court and were explained to that there are no rights to visitation and custody at this point, and assisted with the removal and alienation in this case. Your Honor, these children specifically were enrolled in school here in Fairburn, and the defendant tried to cut off communication and contact with their biological mother after he took them from her home in July, and then refused to return them and went and tried to obtain an order for protection against her. So the state would argue this is an abuse of the system here. The filings filed by this defendant does not indicate that the mom in this case is a resident of Florida. And at this point, he has shown he absolutely disregards the orders of the court. Ms. Pope was represented by counsel during the TPO matter, and her attorney, Mrs. Alexis Putt, P-U-T-T, has been in contact with the defendant and his family. In fact, the final order required that the defendant exchange the children back to Mrs. Pope through her attorney. So not only did the defendant and his family disregard what was told to them by the court in open court, they disregarded the requirements for the exchange of the children. And this is all documented, and efforts to try to avoid where we are today have been profound. As part of my evaluation of this case, I reached out to Fairburn Police. I obtained the last 5 different police reports filed between these individuals. There clearly is some work that needs to be done on co-parenting here, but at this point, Your Honor, based on the behavior of the defendant and his family members, we would request no contact with the children or with Ms. Pope until further order of the court as it relates to the defendant's rights to access to those children. And again, we're asking for a $2,000 SOB through pretrial level 2. Thank you.
Okay. You did? Got all that?
Yes. Your Honor, we understand this has been no legitimation yet. The next hearing on this will be September 27th, as I read the petitions. There is a family violence order in place against her for a year, or approximately a year. I don't know how much is left, sometime into 2025.
It's the order that was just issued on the 19th that also said the children needed to be relinquished back to her care, and that he had no visitation or custody with them.
Yes, I understand.
So the same order that is preventing her from having contact, that's what you want to make sure is enforced. Your client is refusing to follow the orders in the other part of it.
Yes, okay, fine. Thank you. There is no record. We obviously would agree that there should be no further contact until the legitimation process is completed and a determination of the court is made. That again might be late September, maybe later than that. But given his lack of history, we would be seeking a signature bond through the jail. No further contact with Miss Holmes, or I forgot her name actually. Maybe I got that right. Or the children, again, until a court order from the Superior Court. We have no problem with that. We just think the signature bond should be through the jail.
I know it's his first, but I have a problem with all that's been going on. I have a headache listening to it because it's just crazy for these kids. And something's got to give and something's got to stop. And this is ridiculous. And I'm assuming, Ms. Pope, you all are over in the family division?
Yes, this is here in Fulton County in family court.
Okay. So right now, ASG Allen, the children are to be with Miss Pope, right? From
And
the
they have
last
been
order.
relinquished back to her through the assistance of the Fairburn Police and in compliance with the order of the court. Yes, as of yesterday.
As of yesterday.
Mm-hmm.
And I know it's his first, but I don't know if he gets out, is he gonna go snatch him again? I mean, I'm concerned about the actions here.
As is the state, Your Honor.
Mm-hmm. And he has his hand up. I beg to differ of what he has to say.
Yeah, Mr. Holmes, I wouldn't say anything. You've got we're working on a signature bond here. You've got the processes that need to resolve this in place, and you'll know more in late September. But we're talking about in the near term, no further contact with the mother of the children and the children until you can resolve the legitimation and custody through family court, which shouldn't be that long from what I read.
Did you all have something on September 27th?
I think that's the next hearing as I read the documents.
Good afternoon, Your Honor. Can y'all hear me?
No, I asked that you not speak.
Oh.
I don't think there's anything that you're going to tell me. So, Ms. Pope?
I have an important, it's really important if you guys can hear me for just a little bit.
I give you 2 seconds.
Okay, so August 19th, when we had the TPO hearing, I was awarded a 12-month order, and that 12-month order, Ms. Pope was ordered to stay away from the petitioner and the petitioner's minor children because she's a threat. And in there, she was ordered to stay 200 yards away from my residence, their school.
But we're not here on a TPO, so I'm not going to listen to TPO stuff. All I want to hear about is where these kids. All I want to hear about is where the children are supposed to be right now.
No, the court
order, I think they're supposed to be with Ms.
the minor children are relinquished to the petitioner, which was me. And that same night, the police kept coming to my house, and I showed them on the court order that the judge put the minor children are relinquished.
Your Honor, we would object at this point.
Are relinquished to the petitioner.
Absolutely not. There
Ms.
was
Pope,
a mistake written into.
Yeah.
That was taken advantage of by this defendant, and Fairburn Police rectified that issue, as did the court.
Ms. Pope?
Very clear.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? Can't hear you.
Ma'am.
How old are these children?
4 and 2 years old.
4 and 2?
Yes, ma'am.
Oh, they're very small and fragile.
Yes.
And the last order that we have from the family division, is it? Huh?
Yes.
And it says who is supposed to have custody right now?
Me, Your Honor.
Okay. And does he have a protective order against you?
He does. He got one out. The judge did extend it for 12 months, but she was very specific in that TPO that the kids had to come back with me because he has no right.
Okay. So for some reason, he's gotten that confused and can't remember. So here's what I'm going to do. I'm going to give him some time to sit back and think about his actions and calm himself down. These are 2 small children, 4 and 2.
Yes.
They're probably so confused and scared, they don't know which way is up.
Yes, my daughter.
Go ahead.
My daughter was very scared. She just now opening back up to me. She didn't even really want to talk and play at first.
Mm-hmm. And this has got to stop, Mr. Holmes. Because you've got to stop and you've got to let the system take care of it. First of all, you've got to get the legitimation resolved. And until you get an order saying you're the legitimate legal father, you don't have any rights. And it seems like that's where the court has come down. So I'm going to tell you right now, you'll be back down here at the Fulton County Jail, because I'm going to include in my order, according to the last order of the Superior Court, that the children are to be in the custody and care of Miss Pope. And if you come so close as to take them, first of all, you can't even be around her anyway. So if you come around her, she can call the police and have you arrested. Just for violating the TPO. And hold on a second, let me look here at this order because somebody doesn't understand. And I know it may be your first arrest, but I'm not inclined to give you a signature bond based on your actions. Hold on a minute.
Your Honor, there was I don't know if you want to call it a Scribner's error. And so he is correct in saying at one point the language did point to him, but that was obviously, well, from an attorney's point of view, that
What
was
do you
obvious.
mean is it Scribner's error? It either said he
Well,
gets him or he doesn't.
So
Well,
the order of the court on August the 19th mistakenly said, even though there was a whole hearing and it was very clear what the judge's intention was when she stated, and it says in the order that this gentleman has no rights to these children, it erroneously stated petitioner should be in possession of the children. And so that was corrected with an amended order almost immediately by the judge. And it's that individual piece that this defendant is trying to use to say that the judge intended for him to take these children, when during a hearing and in the same, both of those orders, it's very clear he has no rights to these children. It's flagrant. It is abusive. It is a waste of time and resources in order to do this. And frankly, these children are young, and this mom lives in Florida. So filing an order for legitimation and filing a TPO when you know that the respondent isn't even here in the state is completely wrong on all areas.
Yeah.
This is a huge waste of the court's time. And she was prevented from having her children starting July the 16th. I would note that multiple people in support of this defendant are on the Zoom right now. And again, we would request that there be no contact by the defendant or anyone in his family who has perpetuated this strange web that is a flagrant disregard for the law and what people and a judge have told these folks to their face.
All right. I see. And Nicole Pope, is that your sister or someone, Brianna?
My sister and my mother.
Okay. All right. I won't belabor the issue more, but I'm going to obviously have you all. There's an amended order, Mr. Holmes, that says that the kids are to be in the mother's possession and obviously custody and control of her. And she lives in Florida in another state. And so you are not to have custody. You are to stay away, have no further contact with the kids right now, no further contact with the mother, Brianna Pope. I think it's JH and MH, no? I'm trying to remember the children's initials.
JAH.
Go ahead, Miss Pope. It's what?
JAH for both of them.
Oh, JAH for both. Okay. All right. So again, I am telling you, and you're not looking at me, Mr. Holmes. You're looking away talking, and you're not paying attention. You are not, and I'm gonna say it twice for once for each child. You're not to have custody of these children right now. There's an amended order that says that. The order was amended and corrected and fixed. So don't go around them. Yes, Ms. Pope.
I just wanted to ask you, will I get documentations and writing of all of this? Because they keep trying to say that I can't leave the state lines with my kids, and we're not residents of Georgia.
Again, this is an abuse of the system.
Yes.
Terrorize this woman and these children.
I don't see why you can't.
Yes, you'll get a copy of the order. And if Your Honor would please include no contact by the defendant or anyone in his family as it relates to these children.
Right. No one in his family. And he's supposed to stay 200 yards away from her.
She's actually supposed to stay away from him because he got an order for protection against her.
Right. So then both of you. So you can't even be around her anyway. Can't get around her to go try to steal your kids or your alleged children because it's not been solidified by the order of the court. There's no legitimation order in place. But if you do, or if your relatives do, then they can all go to jail with you. And so this is going to stop and it's going to settle down And Ms. Pope, you need to be very careful.
Thank you, Your Honor.
And so we'll put that in there, but let me give the amount. I'm going to give him a $5,000 surety bond, 2,500 on each of the charges. It's going to be a 5,000 surety. And again, I'm ordering him to stay away from you and the children. And right now he's to have no contact. So, whenever that happens, it'll probably be by Superior Court order. But right now, in this court, for state court, he is not to have any contact. No drugs, unprescribed medication, alcohol, weapons while on bond. I would order him to take some anger management. He's got something else going on. I mean, maybe he's just mad because you all aren't together anymore.
I agree.
But what type of work does he do, PD?
He's a truck driver.
Oh, truck driver. Okay. So let's ask him to take a 1-week anger awareness course at his expense. Let's go on the road for a while and get away. Cool down, settle down. Anything else, counsel?
Nothing from the state, Your Honor. Thank you.
Nothing
Anything
further.
else, Ms. Pope?
No, Your Honor. Thank
All
you.
right. Good luck to you. Thank you.
It's crazy. Next, we have position number 8, Mr. Opal.
All right, this is 24 CR 005894H, Arius Opham. 1 count of criminal trespass, pretrial.
First, jail.
Your Honor, we would join with that. We're asking for an SOB through pretrial or the jail at your discretion. This is this defendant's first arrest. This is a delayed arrest. The incident in this case is from
Is that correct?
2022. So there's an
2022?
active warrant since 2022. We are just within the statute of limitations. Evidently, there was an issue at the Publix on Roswell Road, 7525. In August of 2022, dealing with an inappropriate touching. He was criminally trespassed from that location and then seen at the location again in October of 2022. No, excuse me, December of 2022 in violation of that criminal trespass. So investigation was conducted, surveillance was reviewed, and the defendant actually spoke to police on the phone, admitted that he knew there was a criminal trespass warning and going to the location anyway. I believe he was picked up on this warrant in Smyrna. We would ask for $1,000 bond. We'd ask for SOB through pretrial, stay away from the Publix at 7525 Roswell Road. Thank you.
Okay. All right, I will grant that. You don't have any disagreement with that, do you, Mr. PD Cook?
No, that would be Mr. McLean's case.
Oh, McLean, where'd he go? Think his camera's off. Oh, he's on the phone.
So, thank you, Your Honor. Let me get off the phone here. Thank you so
Okay.
much.
All right, so I'm going to order $1,000 signature bond through the jail and stay away from the Publix. No drugs, alcohol, unprescribed medication, or weapons while on bond. And that'll be it.
Thank you, Your Honor.
What was that amount? I'm sorry.
1,000 through the jail, signature to the jail.
Okay.
Is that it?
We have
No.
position 10 that
10.
waived their appearance.
10's a waiver, okay. Is that the last one?
Yes.
Okay. All right, we'll do position 10, which is 24 CR 005871F. LeVar Reed, charged with 2 counts of battery, pretrial.
You got an open fleeing an officer window tent. Open possession of a firearm by first offender, theft by receiving. It's 19 SC 167 195. On parole for ag battery. On probation for ag assault, possession of a pistol or revolver by person under 18, pointing pistol or aiming it at another. What else? And he has a parole hold, so he ain't going nowhere.
Okay.
And that's my case, Your Honor. This is an incident from May the 15th of 2024. The victim, Jasmine Pritchett, is on the phone or on Zoom, excuse me. We've been in contact with her, but just briefly, the defendant and the victim don't know each other. They had met up at the location with a group of people. She was able to identify him through his Instagram handle, and investigation by police identified Mr. Reed as the person who is associated with that Instagram handle, Rude Boy. They all met up at Perkerson Park, and during that meetup and hangout, the girl that this defendant was with started arguing with someone, and the defendant punched Mrs. Pritchett in the face multiple times. She actually had to have surgery to pull her teeth back into place. She hasn't seen or spoken to the defendant since then. I would note that the police report indicates that this defendant is a known gang member. His aggravated assault conviction in 2014 for an aggravated assault and aggravated battery, he actually received first offender on, although evidence was presented of his gang involvement. He's got a possession of a firearm by a first offender that is in judicial hold, Your Honor. That's an 18 SC case, and an open new case from July of 2025 that includes possession of a firearm as well.
I mean, 24. You said 25.
I'm sorry, 24. We're not there yet.
We're not there yet.
Yes, July 25th, 2024. This is a violent individual. This victim, once we are provided some documentation, we'll probably be asking that this be elevated to an aggravated battery. But at this point, you've got 2 counts of battery in front of you. We'd ask for a $4,000 good bond, absolutely no contact with the victim, Jasmine Pritchett, Pritchett, and no drugs, alcohol, or weapons while on bond. The location of this incident is Perkerson Park. We're not asking for a stay away or anything related to a location. Thank you.
All right. Jasmine Pritchett, do you want to address the court today at all? Is that her on JAS?
I believe so, Your Honor. This case was on our SEA yesterday, and the defendant refused to appear and said that his attorney, Matthew Carrington, would be representing him. That gentleman is not available, has reported that the defendant has not paid him. And so we're here today after it was reset. He has again waived his appearance and refused to appear, but Miss Jasmine has joined us again. We've been in touch with her. Thank you.
All right. It's a terrible, terrible case. How many cycles did he have?
Pre-trial, can you help the judge with the number of cycles for Mr. Reed?
So we're not.
How many cycles? I heard you reading, and I
Yeah,
wrote
I didn't write it down.
2 open cases.
Give me a moment.
I heard about the 18 FC and the 24.
And Your Honor, while we're waiting on him to come back, I have not received that waiver, Mr. McLean. So will you please send over the waiver for this case?
Oh, we can do that, certainly.
Thank you. And I don't know which PD is handling the other case with the evaluation. If you all will prepare that as well.
Mr.
Yeah, was that McLean?
Yes, we'll.
Okay, so that's 2 things then, Mr. McLean.
Right.
This is 8th arrest.
Okay.
8. All right.
I'm going to order $6,000 surety bond.
I was gonna say-
$3,000 on each. Huh?
Your Honor, I was going to say that he did waive his presence. He understands about the parole hold, and he just said, well, just go ahead and handle the bond, any bond that the court feels. I understand what the state is recommending, something in that neighborhood of 4,000 or perhaps 3 is what he would recommend.
Based on his history and the factual allegations in this case, I'd love to go higher and make it all cash just because it's a horrible case. I want to make sure the victim in some shape, form, or fashion can feel safe, that he won't be getting out anytime soon. But I'm comfortable with the 6,000, 3,000 on each. No further contact with the victim, Jasmine Pritchett. I could order him to stay out of Perkerson Park if that's where he goes to do certain things, but if the state's not asking, I won't go that far then. No drugs, alcohol, weapons, or guns, or unprescribed medication while on bond. That's it.
Okay.
And Your Honor, was that a good bond or a surety bond?
Surety bond.
Thank you.
What was that dollar amount?
6,000, 3,000 on each. Surety.
Yeah, I think that completes the calendar.
All right.
Do we have a Sigler?
Have a
I'm
who?
sorry?
Sigler?
No.
I submitted an NOD for that case, Mr. McLean. It's past the statute of limitations. He has an open case that's in bench warrant status, however.
Okay. I was going to tell you that the dad had died in 2022.
Well, lucky for your client, he's not going to get another crime against someone yet.
Okay, once again, the reset date for the SAP calendar is September the 5th. Position number 1 is reset further notice with a total $3,000 SOB through pretrial. Position number 2 is going to the SAP calendar with a $3,000 good bond. Position number 3, SAP calendar with a total $3,500 good bond. 4, SAP calendar with a $2,500 good bond. 5 is going to the SAP calendar with a total $3,000 split bond. 6, SAP calendar with a total $5,000 good bond. 7, SAP calendar with a total $5,000 good bond. 8, reset further notice with a $1,000 SOB through the jail. Position number 9 received a $4,000 good bond, and this case has been transferred to Superior Court. Position number 10 is going to the SAP calendar with a total $6,000 good bond. 11, reset further notice with a total $4,000 SOB through pretrial. 12, SAP calendar with a total $2,000 good bond. And we have an add-on, which is going to the SAP calendar with a total $5,000 good bond. Are there any questions, comments, or otherwise?
Thank you, Ms. Bridgewater.
Bye.
Okay. Mr. McLean, I'll be waiting on you.
Well, bye to you too.
Thank you, everyone.
All right, everybody.
Okay,
Take
thank you,
care.
guys.
See you
Bye-bye.